Join us every Wednesday for InFocus, a weekly talk show produced by the SKNIS Information Service, where we provide exclusives with key persons within the government and discuss pertinent, relevant, and interesting matters that affect us all. Tune in every Wednesday, live on ZIZ Radio and streamed live on Facebook at SKNIS Media and ZIZ Online. InFocus, your government, your business.
I'm Ian Richards, welcoming you to InFocus, a weekly program where we take a closer look at what's happening within and across the government of St. Kitts and Nevis, your government. Passed in the National Assembly on September 24 and amended in July 2025, the judge-alone trials legislation has sparked national interest and discussion about its role, impact, and what it means for fairness and transparency in the High Court in St. Kitts and Nevis. Joining us today to explain what judge-alone trials are, why it was introduced and how it is impacting the administration of justice, is Adlai Smith, Director of Public Prosecutions. Stay with us for InFocus as we deepen your understanding of judge-alone trials.
Madam Deputy Speaker, if you allow me to start with some statistics from the High Court. Over the past 10 months, since the Judge-Alone Trials Act has been in operation, there were 33 criminal cases completed in the High Court over those 10 months. 17 of those were guilty pleas, 3 were judge-alone trials. Therefore, less than 10% of the matters resolved in the last 10 months in the High Court, the St. Kitts Circuit, were resolved by judge-alone trial.
Welcome back to InFocus, and please join me in welcoming back to our set, the Director of Public Prosecutions, Mr. Adlai Smith. Mr. Smith, it's always good to have you back with us.
It's been a while.
Yes, it has been, and you've been trying to get on the show for a while to discuss judge-alone trials. It's something that you're very passionate about.
Yes, I am passionate. I'm passionate about most things, law reform related. This is just one of them. As you had indicated in your opening salvo, the legislation was passed last year, around September 20th, I think. It got the green light. And I believe you want to know a little bit about why?
We can start there. But before we get into why the legislation, first off, let's give an explanation as to what is judge-alone trials.
Judge-alone trials. Well, as the name implies, it is a mode of criminal proceedings or trial whereby the judge is the trier of fact and the trier of law. At the end of trial, he gives a verdict. What do I mean by that? We are familiar with what the jury trial is. The jurors are the trier of facts. They determine what the facts are after having listened to the evidence. After they listen to the evidence, the judge gives them directions of the law by which they assess the evidence, and then they're sent out to give a verdict. Now, in the judge-alone trial, the judge does both the fact-finding and he directs himself on the principles of law which are applicable. And technically, in a sense, you already had judge-alone trials before the legislation was passed, because magistrates are judges in and of their own right. They determine the facts in the magistrate's court and they come to a verdict in the magistrate's court.
But magistrates deals with less serious matters.
Yes, but at the same time too, there are some matters which magistrates can deal with at the same time with judges. When I say that, I mean you have firearm offenses can be tried in the magistrate's court or in the High Court. The difference really is only the maximum penalty. Certain forms of wounding tried in the magistrate's court and in the High Court. Certain forms of theft triable in the High Court and in the magistrate's court. They're all, they're all offenses which can be tried either by judge in the magistrate or by jury in the High Court before the passage of the legislation.
So what determines that, whether it's tried in the magistrate or the High Court?
Okay. Presently, right? Because as you're aware, there was an amendment to the legislation in around July of this year.
That's right.
That's because there was an error. I mean, human beings prone to error and so on. There was an error in the legislation which caused a bit of ambiguity in the court. So I wrote to the Attorney General indicating that this particular error needs to be rectified. And so we've rectified that particular issue in the legislation. So I think it would be helpful from the outset to let you know what the regime is with respect to judge-alone trials. Now, under the current dispensation, there are some matters, not all, some matters which will be tried by judge alone under the legislation. And then for those matters which are not mandatory judge alone, they can become judge alone via an application.
Okay. Let me back you up.
Yes.
You said there are some matters. What are those matters?
Okay. Now there are a list of laws. I don't want to use fancy legal expressions because I'm mindful I'm speaking to members of the public. Mm-hmm. Right. There are some laws which, based on the offenses in those particular laws, it's listed in the schedule of the legislation, and those offenses which are indictable under that act, when I say indictable, I mean they're tried in the High Court only, right? Those will be judge-alone offenses. And I can give you some examples because there was a long list. I actually had them written down. Offenses under the Larceny Act, so that covers theft, robbery, burglary. Offenses under the Forgery Act, that speaks for itself. Offenses on the Anti-Corruption Act, the Whistleblowers Protection Act, and that trilogy of anti-corruption legislation. The drugs legislation, the proceeds of crime legislation, which deals with money laundering, the gang legislation, offenses under the recently passed Justice Interference Prevention Act in 2024, the Genocide Act, the Electronic Crimes Act, and the Anti-Terrorism, Trafficking in Persons, Explosive Act legislation, taking of hostages, anti-smuggling of migrants. Those, to name a few, on the legislation, and there's some offenses specific under the Offenses Against the Person Act, whereby attempted murder will now be mandatory judge alone, along with shooting with intent. And to round it off, we have attempting to pervert the course of public justice and conspiracy to defraud. So offenses under these pieces of legislation or under these laws, these will now be mandatory judge alone. You notice that I did not mention sexual offenses. Sexual offenses will continue to remain the province of the jury, and all of the other offenses outside of that. So then the next logical question will be, how then do those other offenses become triable by judge alone? And I was starting to indicate that there has to be an application. The application can be made either by the prosecutor or by the defense attorney. And the guiding principle insofar as determining whether the trial should be judge alone or not is the interest of justice. Now, the judge determines what is in the interest of justice, having regard to a range of different factors. Some of these are repeated from in the old legislation. Like, for example, if there is a lot of prejudicial pretrial publicity, or a case has a lot of public interest in it, so that there's a possibility that, or distinct possibility that the potential jurors may be tainted by the information, where an offense, and this would apply maybe, not maybe, but more likely to robbery and certain types of murder, if there's a gang element or gang component in that, if there is a risk of witness interference or jury tampering, if, for example, let me see, I do have some of them written. Oh yes, the nature and the complexity of the trial, and having regard to the length of the trial, those are factors which the judge can consider.
But before we go there, I want to keep it focused initially on the legislation, because the legislation is what introduced judge-alone trials for the High Court. And so that is probably the next question I would ask you. Why was it necessary to have that introduced the legislation, particularly to have it introduced in the High Court? Could it have been done any other way?
Well, first off, when you say any other way, what other way could it have been done?
Well, I'm asking you.
Well, there are a number of reasons why we could have introduced judge-alone legislation, trial by judge-alone legislation. I don't know if you've ever heard of the Needham Points Declaration,
no.
But that was you can call it a conference or a summit whereby Caribbean leaders and stakeholders in the criminal justice all over the CARICOM region met together, and they were talking about the problems associated with criminal justice in the region. And at the end of that particular conference, they had a declaration which is considered an aspirational document. In other words, a set of principles which we should aspire to. And among those is for the countries, while considering that crime had become a public health emergency in CARICOM, one of the ways of dealing with that is to consider judge-alone trials as a complement to jury trials in the jurisdiction. Now, I'm sure you're aware, if you're not aware, everybody out there probably knows somebody or has a matter that is before the court. And the problem, or the complaint rather, is the same all over, not just here in St. Kitts, over and over. Why is it that criminal trials take so long to come off? Now, my answer to that is one mode of dealing with that, because there's no silver bullet in terms of dealing with the issue of delay in the courts. But one way of that is complementing your jury system with judge-alone trials, right? Judge-alone trials, if handled in the right way, can be an efficient way of bringing a trial to a speedy resolution. I can draw an example. The first judge-alone trial in Trinidad, which also has judge-alone trial legislation, which is different from ours, though. The first judge-alone trial lasted 20 minutes. It ended in an acquittal, but you see, the thing is, in judge-alone trials, the judge is focused only on what is in issue, right? Because, of course, in a trial, there's some things, some issues, or some facts that we can agree on, and there's some facts which are contested. But I'm sure we can deal with that later. I'm sure you have a question covering that.
Right.
I don't want to jump your gun.
Right. So from your perspective as DPP, then how has judge-alone trials, because of course you just spoke about the fact that 20 minutes, and there are a whole lot of questions that I can follow up on that, but I'll do that later. But how has it impacted the criminal justice and the administration of justice here in St. Kitts and Nevis, having judge-alone trials?
Okay. Well, let me start with a quotation. I believe it's Justice Adrian Saunders had made a comment along these lines in a Caribbean Court of Justice case called Kalini Flowers, right? And there was some by the way remarks made about judge-alone trials versus jury trials. And one of the things he mentioned in there was that jury trials, even though they were once considered the bulwark, that's the word he uses. I don't know who uses that term nowadays, but a bulwark is a defense or like a fort or something, some means of protection in societies, historically speaking. However, moving into modern times, we have a problem whereby, one, there's a clamor for transparency in terms of how we arrive at decisions. Now, of course, you know, jurors aren't required to give reasons for their decisions. And I'm sure we can go into this later. But judges under the judge-alone trial regime satisfies this clamor for transparency by having to give reasons for their decisions, right? And he mentioned also too that judge-alone trials in modern times have become more necessary because of this phenomenon known as witness tampering or witness intimidation. And dare I say, witness intimidation, and as of late, jury intimidation, is rife all well and good in the Federation of St. Kitts and Nevis. The question is, in the face of that, does Parliament just sit back and do nothing? I mean, it is the Office of the Director of Public Prosecutions which is pushing or at the helm when it comes to advancing legislative reform in the country, because it is important. So, having regard to the issue of witness tampering, Justice Saunders went on to indicate why judge-alone trials, not to say that to be judge-alone trials in every instance, but judge-alone trials have a newfound significance in the modern age.
So how would you say, because you still didn't touch on the impact for the criminal justice system here locally, how has it impacted since we've had that legislation passed?
Oh yeah, you see, the reason why I mentioned the intimidation, because I spoke about the fact that witness intimidation and jury intimidation are rife. I understand that the Attorney General has mentioned in Parliament about a particular case in which there was jury interference. And it was jury interference, though not the same, but the same principle arose. I'm sure you might have heard of the Vibes Cartel case, the famous Vibes Cartel case which went to the Privy Council. They ordered the retrial. Remember the issue in that particular case, the foreman or the members of jury were offered a bribe, and they ended up finding the good gentleman guilty nonetheless, but the Privy Council said, no. You see, the fact that the jury members were tainted by that, if they were hearing about this offer of bribe and so on, it may cause them to overcompensate for the fact that they were told that by finding him guilty. So in the particular case in St. Kitts and Nevis, why, this is something else. A family member of a juror was contacted by somebody, and they were told pretty much basically, you must find the accused guilty and tell the other jurors to find them not guilty, right? And that was communicated to the other jurors in the case, and it was eventually reported to the court. Now, in accordance with the principles established by the Privy Council in the same Vibes Cartel case, where there is a case of jury interference, there ought to be an investigation. The judge conducted an investigation. Coming out of that investigation, found that 5 of the jurors thought that the accused was likely guilty. Otherwise, why would the person have approached family member of the jury? So the question then arose, do we continue the trial? Right? Now, you would think, right, that defense counsel would want to abort the trial, but they didn't.
Move for dismissal.
No, they said they wanted to continue the trial with the same jury. No, me no foolie. Anyhow, I was defense counsel, and me hear that 5 jurors would have found my man guilty, but they said they wanted to continue. So overnight, you know what I did? I said, what? Okay, you want to continue? I wrote a letter to the defense counsel, and I said, look, I don't have a problem continuing the trial, but sign an undertaking that you won't use that as a ground of appeal. The next day, they come, they saw, I had a chance to consider it. Not one of them signed any undertaking. You know what that says? They wanted to continue, take advantage of the fact that in the case of a guilty verdict, they could still appeal and still use that.
Right.
That's what I have to contend with. Right? So, because, let me make another reference to the same Vibes Cartel case. In the cartel case, the trial had gone about 64 days, right? 64 trial days. So that's more than 2 months. That probably could be going into 3 months if we're just counting the working days. I think around the time of jury interference in the case here in St. Kitts, we're probably gone about 2 months into the trial. Now, the Privy Council said, the judge, he really ought to have discharged the jury unless he had provisions which are analogous in England, whereby the trial could continue as a judge-alone trial if certain factors were done. Well, because we passed the legislation back in September and adopted those same provisions in England, we were able now, after making legal arguments, to ask for it to continue as a judge-alone trial. So, from that standpoint, we saved 2 months, 2 months of court work, right? 2 months. And if you consider 2 months is a long time, because the court term generally is about 3 months. Yeah, in case anybody argue, somewhere around there. So we'd save time and resources as a result of having that particular provision. Otherwise, it would mean we'd have to start over that whole matter from scratch. And mind you, we already have a lot of matters as is on the High Court docket, right? Persons who are waiting for trial from, I think we just finished a 2018 matter also.
In 2025.
In 2020, I mean, that's rare. Mm-hmm. That's rare. But the point is, we can't have matters just sitting around doing nothing. We have to find a way. And maybe another time we can talk about the whole issue of delay, because I know this is something on the public's mind insofar as what are we doing to deal with the delay. So from that standpoint, there's been tremendous benefit as a result of having that legislation to continue a trial as a judge-alone trial in the instance of jury interference.
You mentioned the Attorney General's statement in Parliament, and persons would have heard during our break the voice of the Attorney General speaking about the judge-alone trial legislation, the amendment when it was being debated in Parliament. At the time, he also mentioned that there were 33 criminal cases that were completed up to July 2025. Only 3 were judge-alone trials. Has there been any more judge-alone trials since the act was passed, when the AG mentioned that at July 2025?
I know there have been at least 2 other judge-alone trials, but in those instances, they did not go all the way to verdict. The accused pleaded guilty, threw in the towel in the middle of the trial, and those just ended a natural death, so to speak. Those persons have been sentenced.
Do you think that outcome would have been the same? And it's hard, because I'm not necessarily asking you to think and to speculate, but of course, as a lawyer,
you've answered your own question.
Right. But is it more likely that persons, especially given that there may be no opportunities to influence a juror, someone may be emotional, there's a lot of things to consider when you're using a jury trial, that because it's based on evidence, that you're more likely to just plead guilty if you know that you did the crime and you feel that there's not a way for you to more or less wiggle out of a charge?
Well, I mean, let's put it this way. Let's start from the premise that the criminal justice system cannot survive without people making guilty pleas, right? A lot of the matters that are disposed of are via guilty pleas. I think over the course of the last year or so, let me see, there might have been 3 trials in the September sitting, 3.5, 2 trials, full trials I'm talking, in the January sitting, 1 trial last term. Those aren't big numbers. But you're hearing that there have been 33 matters disposed of since the passage of the legislation. That is because persons are pleading guilty, are taking accountability for their actions. And I just want to say, just a brief segue, this is part of the reason why persons are given up to 1/3 discount when they plead guilty at the earliest available opportunity, because they are not wasting the court's time. They're saving the court's time, because it's simply not possible to try all of those matters in a short space of time. Just for argument's sake, I think, in case anybody argue, in a court term, which I said was about maybe 3 or 4 months, you can't really do more than 5, 6 full trials, And if you have a docket which has over 50, 60 matters on there, and criminals are continuing to commit crimes. Our people are continuing to get charged for crime, let me put it that way. Because people who commit crime don't go on vacation or sick leave, right? You're going to have cases coming in faster than you can dispose of them if you had to try every matter. And in that case, the criminal justice system would collapse. So we have to find ways in which we can deal with the matters within the system. So I just thought I'd segue briefly into that.
Right, and of course, as you mentioned, that helps to speed up the administration of justice, as that's definitely one of the benefits here. All right, we're going to have to take our first break, Mr. Smith. When we come back, we're going to talk about concerns that persons have raised about judge-alone trials.
Sure.
Stay right there, viewers and listeners. We'll be right back with more In Focus.
If you haven't done it as yet, please do it today. Subscribe to our YouTube page at SKNIS Media for regular updates, live coverage, and even more information on your government. While you're at it, like, share, and interact with our Facebook and Instagram pages at SKNIS Media and SKNIS Info.
Welcome back to In Focus. We continue our discussion with the Director of Public Prosecutions, Mr. Adlai Smith, and our discussion is understanding judge-alone trials here in St. Kitts and Nevis. Now, Mr. Smith, I mentioned concerns, and I'll point out to one, but I perhaps will probably come back to you and ask you, what have you heard in terms of, from the public, in terms of concerns about judge-alone trials? But there's one in particular I want you to address, and that would be, is that it undermines the right of an individual to a fair trial, because of course everyone is presumed innocent until proven guilty. What's your response?
Well, again, I've said already that you already have judge-alone trials in the form of magistrates. So if that is the case in terms of dealing with matters in the High Court, then by parity of reasoning, that should apply also to the magistrates. So we should not have magistrates. We should have judge-alone trials in the magistrates' court as well, jury trials in the magistrates' court as well. But I can tell you that if you were to have that, you would have a lengthy trial process, because there are some things which are inherent in a jury trial which actually make a trial much longer. But I'm sure you're going to ask about, the difference after.
No, well, go ahead.
I thought I would indicate that. The courts have already said that there is no inherent unfairness in judge-alone trials. As a matter of fact, you can achieve justice by both routes. It's just a difference with respect to who gives the verdict. The same trial safeguards or guardrails which are in a jury trial are also in a judge-alone trial as well. And when I'm speaking about judge-alone trial, I'm speaking in the context of trial by judges in the High Court. Right? Like, for example, when it comes to, I told you already that before a jury goes out to deliberate, it has to get directions on law from the judge. Well, because the judge is the trier of law and fact in the judge-alone trial, while he doesn't read out a set of directions to himself, in his verdict, he has to make reference to those directions. So that safeguard is there.
And of course, persons can read that verdict as well, too.
Yes, and that is the sweet part. Because if I can just use that as an opportunity, as you asked the question, to show you or let you understand the dynamics of a judge-alone trial and why it is shorter. The jury trial, for example, putting the jury together at the beginning could take as much as maybe 35 minutes, 45 minutes, an hour and a half, depending on how many counts, how many jurors, how many persons know the accused, because questions are asked of them and so on and so forth. There isn't that in the judge-alone trial. Also, too, sometimes there are legal points raised in the absence of the jury, which take up time and so on. And every time the jury have to get up, you have to wait for them to go out, and wait for them to come back and so on. Or think of issues where, for example, there is a confession that is challenged, right? The judge hears evidence with respect to whether that confession is voluntary in the absence of the jury. So you have to call witnesses and so on to deal with that. And if the judge allows that confession to go before the jury, when the jury come back in, we have to hear that evidence all over again. So these things cause jury trials to be longer. It doesn't necessarily mean that unnecessary length is always a bad thing, right? But I'm just telling you the contrast between the two. Now, when it comes to a judge-alone trial legislation is inbuilt with case management mechanisms. In other words, you don't call every possible witness who could speak to the issue. The judge, in a process called case management, which occurs before the trial, determines, as between the defense and the prosecution, what are the things which are in issue in the trial. In other words, what aspects of the trial are contested, right? What aspects of the evidence can be agreed or not contested. And so when those aspects of the evidence are agreed, they're put together in one document called agreed facts. So the advantage of that is that you don't have to bring persons who would necessarily come and speak to that issue, and you save time and convenience there, if you follow what I'm saying. All right. So after you've discovered what the issues are in the case, the next question is, what witnesses are necessary to be called to deal with those particular issues? And those are the witnesses which are called or cross-examined, plus any other witness that the defense thinks that is necessary to bring as well. And then at the end of the case, when you have the verdict deals with the different issues which the judge had to decide, as well as the different directions. And you see that itemized. And you see, well, okay, the judge said he heard evidence from this particular witness. He indicates he believes this particular witness. He indicates why he believes that particular witness. And he goes down the line, and layer by layer, step by step, he shows you how he reaches that verdict. Now, you don't have that advantage in a jury trial.
Right. Because, of course, the jury, the deliberations, unless the case is, and you say that sometimes in the United States, where they will come out and make statements and say, you know, this was a consideration, that was a consideration, and you wonder how much of it is played, especially when they're choosing the jury, how much of it is played by your own social bias or your background or maybe some affiliation that persons don't know about. Choosing a jury can be very, very complicated as well too, but the judge has to stick to the evidence. So questions then, based on what you're saying, who decides if a jury, if a trial can be judged alone? Can a victim, can a defendant, is it the prosecutor's office, is it up to the judge?
A victim, no. I think I addressed this question briefly before. Under our new dispensation of judge-alone legislation, both the prosecution and the defendant can apply for a judge-alone trial if it's in the interest of justice to do so. And I'd gone through the different factors which amount to interest of justice. Not the victim, either the prosecution or the defense can make the application.
All right. So does it undermine a person's right to have a jury, to be tried by their peers?
Undermining, again, it comes back to the fact that the same safeguards which are in a jury trial to make it fair apply also in a judge-alone trial. And I want to go a little bit into other guardrails or safeguards which are inbuilt into the trial by judge-alone legislation, in particular the amendment. Because first and foremost, when it comes to law reform, you don't just pass a law and you just wait and see and hope. You monitor it and see how it's working in practice. And based on how it works in practice, you determine, okay, I foresee that this could be an issue in the future. And you be proactive, and our office would make the recommendations to the Attorney General's office. Like, for example, with respect to if you had a situation where a judge heard a particular witness on one occasion, he was a material witness, and he thought that this person was a person of great credibility, a person of honesty, and so on and so forth. Suppose that same witness now appears in another jury trial as a material witness. The judge naturally, whether instinctively or subconsciously or whatever, you may take into account the fact that this person has been believable before. So we put into the legislation, if it's a situation where there is, the judge has made pronouncements with respect to the credibility of a witness before, and the person is also a witness in a next case, he has to recuse himself, whether by application. This is the other guardrail that we put in. Situations where the judge, whether by his own, we call it his own motion, whether, him telling himself that he must recuse, or by an application by the parties where you must recuse yourself. And these safeguards were put in to ensure that there is fairness. That is one of them. He now has the option, if he determines that it's in the interests of in the public interest or the interest of justice, that the matter is better dealt with as a jury trial, he can decide that. And also, you may have the situation, and this is again proactive thinking on the part of my department, you may have a situation where an application for a judge alone trial, for those matters which are not mandatory judge alone, may be asked for an improper purpose. So if the judge discerns that whether it be prosecution or defense, that reason they're given, they're looking shady, right? I'm not going to grant that. He has that. He doesn't have to, even though it may look good on paper, if it seems that to him that either party is asking for a judge alone trial for an improper purpose, then he can decline to make the trial a judge alone trial. Another guardrail, apart from the reasons guardrail, we have spoken to that because reasons are important. Reasons augur well for transparency insofar as how a judge arrives at a verdict. But there's also the appeal process. The similar safeguards which obtain in a jury trial, obtain in a judge alone trial, but with some differences. Like, for example, with the addition that if, for example, the judge is biased or has been corrupt, or bias, corruption, right, you can have a situation where that can be a ground of appeal. If the judge arrived at a decision which no reasonable trier of fact would have arrived at, that also is a ground of appeal. If the judge did not allow in evidence which ought to have been allowed, if he refused to allow it in, that also is a ground of appeal. And similar, if he allowed in evidence which ought not to have been allowed, that also is a ground of appeal on the legislation. So, short point is, same safeguards and more, which apply on the, and this is not all of them, but I'm just listing some of them for the purpose of making the point. Same safeguards which are in a jury trial are also in a judge alone trial as well. So there's no diminution, that's the word, diminution or devaluation of justice simply because a trial is a judge alone trial.
Let me come back to something you said earlier, and I promised I would, and it's relation to the sexual offenses. Because those are very private matters, especially in the case where...
That's one way of putting it.
There may be an underage individual involved, a juvenile. One could argue that that is the type of case that you would want to keep sensitive, that you wouldn't necessarily want too many persons in the community exposed to the details of such. So why wouldn't sexual offenses be considered for judge-alone trials?
You see, because sexual offenses touch on societal morals, what men and women in the Federation would regard as appropriate behavior, appropriate conduct, and inappropriate conduct. That, more than other relatively straightforward cases, like, for example, theft and robbery and some instances of, money laundering and so on, drugs and so on and so forth, really have nothing to do with standards. But when it comes to deal with what is appropriate or inappropriate behavior, like, for example, you have a circumstance where, a man and a woman may be in a band, jamming, carnival, nice music playing and so on, women dressed in, bra beads and feathers and so on. A man decided to take a wine on the lady. Is that indecent assault? Should a judge determine, whether this is appropriate to, quote unquote, thief a wine, or is that an issue best left for the jury? If you follow what I'm saying, right? So the short point is that when it comes to sexual offenses in particular, and I don't know, wherever I go, the public is always up in arms when it comes to sexual offenses, especially those involving children, not just the manner of commission of the offenses, but there's always an issue with respect to the sentencing in relation to sexual offenders. Everywhere I go, it's always that it's just never enough.
Right. Okay, you touched on it earlier in terms of a compromised judge, a biased judge, because of course at the end of the day they are individuals as well. So, and some of the guardrails are there to protect it. But in terms of identifying it during a trial, is there a system where that can be done, or does it have to go to the end, to the verdict, so that it can be appealed? How will that be addressed?
Oh, when exactly? The appeal process kicks in after the verdict, right? One thing I didn't mention was that at the end of a trial, the judge, according to the legislation, has 14 days in which to deliver his written decision to the parties. And then the beauty, because the reasoning and so on is already in the written document, it allows for more focused points for appeal and make it easier for the Court of Appeal to determine, well, okay, this is the narrow issue with respect to how the judge dealt with this particular bit of evidence, or whether this aspect of his verdict is unreasonable or cannot be supported by the evidence, etc., etc.
Can a judge refuse an application for a judge alone trial?
Yes, if he thinks it's in the interest of justice to do so, he can.
Okay. Has that happened?
Well, this is under the new dispensation, right? They are under the new amendment. And again, the new amendment was to offer clarity. One of the differences between the amendment and the old legislation is that you did not have a situation where both parties had the opportunity to make an application for a judge alone trial. It was just the prosecution. What we have found in actual practice, defense lawyers actually do want to make applications for judge alone trial. And so we put that in the legislation to give them an equal opportunity to make an application for a judge alone trial. As a matter of fact, speaking from the Antigua experience, there's one particular lawyer, because judge alone trials did come under some heat when they were when they became law in Antigua and Barbuda. But then after a while, when they realized that, because judge alone trials are hard to get convictions in, prosecution has to do a lot more rather than the sway and the theater of before a jury to get a verdict. But because the judge focused cleanly on the facts, a lot of cases were getting acquittals. So one lawyer told me if he had a choice, he always asks for a judge alone trial. If he can, I think he was one of the, it was him or some other lawyer, asked for a judge alone trial in a sexual offense matter, and the matter, I think, got dismissed by no case submission. No. It went to a verdict, but the individual was found not guilty.
But Mr. Smith, has a judge refused a judge alone trial application here? That's the question that I asked.
Okay, sorry, because I was thinking under the new dispensation, right? I remember, as you say so, there was an application for a judge alone trial. I mean, I didn't make that myself, it's one of my other counsel. And they were unsuccessful in getting a judge alone trial. That's the one that I know of.
Okay.
But generally speaking, because we will have grounds, right? We do ask for judge alone trials where there's a gang component in the case, and we try to establish the gang component and so on. And we've generally been successful where that is concerned. If there's clear evidence of witness tampering and so on, we've had a case where there had been witness tampering. There was a calling of a witness from in the prison and so on, and we were able to use that as grounds for a judge-alone trial.
Okay, all right. So you mentioned Antigua, and you also mentioned earlier in our interview Trinidad. And so we're going to talk a bit more about how judge-alone trials is used within the region, where it's being used. We want to establish those and enlighten ourselves in terms of that discussion, because as I mentioned, our discussion today is all about understanding judge-alone trials, and so it's not unique to St. Kitts and Nevis, as you have clearly indicated.
No, it's not unique.
So we're going to take our final break, and then we'll come back and have that discussion.
All right, no problem.
Stay with us. We'll be right back with more In Focus.
This move being led in the Caribbean is being recognized throughout the world. A government commission review by Sir Brian Levison warns that England and Wales Crown Courts are facing collapse under a record backlog of 75,000 cases, some delayed until 2029, and recommends removing the right to jury trials, replacing them with judge-led trials, and incentivizing early guilty pleas. So we're not just doing it in the Caribbean. What we're doing in the Caribbean is being recognized and adopted internationally.
Welcome back to In Focus. We continue our discussion with Adlai Smith, Director of Public Prosecutions, and we're discussing understanding judge-alone trials here in St. Kitts and Nevis. So, Mr. Smith, let's move on and talk a bit about, as I mentioned, the regional perspective for judge-alone trials. How many countries have adopted judge-alone trials, and if you could give us a sense as to, not necessarily the day and the month, but when they were introduced?
I can't say I know when all of them were introduced. I know Antigua was definitely during COVID, for sure, during that COVID period. Trinidad was somewhere around 2020, thereabouts. They passed their legislation.
So around the same period as well, too. Because COVID was 2019 to 2022 around.
Okay, somewhere around there, around that same period. Turks and Caicos was definitely before that, because Turks and Caicos has judge-alone legislation. I understand Cayman Islands has judge-alone legislation. Belize has judge-alone legislation. Don't quote me on this. I think that might have been in 2015 or 2016, but I stand corrected if I'm wrong. And Jamaica, I think, has had judge-alone trials ever since the 70s, the late 70s. I think case Trevor Stone, I think there was probably a challenge to the constitutionality of the gun court. I'm sure you've heard of the famous gun court in Jamaica.
Right.
The gun court tries all firearm offenses, all firearm offenses in the High Court, whether it be murder, robbery, possession of a firearm, and so on and so forth. So those are countries which have trial by judge-alone legislation. I think also, more recently, they would have an amendment whereby either the prosecution or the defendant can apply for a judge-alone trial in Jamaica. In Trinidad, at least when I was reading for that around the time of COVID and so on, they had a situation where it was the accused that had to apply for a judge-alone trial. In Belize, either the prosecution or the prosecution? I know the prosecution can apply for a judge-alone trial. In the Turks and Caicos, there are interest of justice considerations based on similar principles to what I had said before: complexity, witness interference, etc., nature and length of the case, and so on.
So how would you say those experiences, those islands that you mentioned, their experiences would have to shape the legislation here in St. Kitts and Nevis?
Well, let's put it this way. Our legislation is loosely based on Antigua's legislation, and I had a direct say in the contents of the Antigua legislation in terms of how it is in its form. They didn't take every provision that I had suggested in there, notably the one from the UK, whereby you can have a trial continue as a judge-alone trial, though it started as a jury trial in case of jury interference or otherwise. But if we look at the Antigua situation is really a hybrid between the Belizean legislation and the Trinidadian legislation. The Trinidadian legislation from the sense of allowing the accused the opportunity to make an application for the trial, and the Belize situation whereby, similar to the Turks and Caicos situation, but only that circumstances with the prosecution can apply for judge-alone trials. So we now have a mix of the Trinidadian, the Antiguan, and the Belizean legislation, because the provisions read somewhat similar. But we are in the process of crafting our own, or making it our own legislation with respect to these additional amendments, because we see that there's a need to improve the legislation.
Mm-hmm. And in terms of the cases, the number of cases and the experiences basically, is it within par with what's happening in the region as well too, in terms of the number of cases?
That regrettably, I don't know the full statistics for that. I really would have to do some serious research with respect to that. But I mean, like judge-alone trials, let's put it this way: a system is only as good as the integrity of the persons who are the stakeholders in the system, right? Let's not fool ourselves. There will always be issues with the jury system, and we may very well find that there may be some issues with the trial by judge-alone system. The question is, when those issues arise, what do we do? What measures can we pass to either eliminate or mitigate that particular risk? So from that particular standpoint, legislation is always under observation to see if it is achieving the objectives it's supposed to achieve. Because like I said, one of the objectives is to deal with complex matters and so on, or long matters, and to save time and so on. And to some extent, it has been doing that. There is room for improvement, but it's a work in progress.
So in that same vein, who's responsible for determining the success or measuring the success and effectiveness of judge-alone trials?
Well, the question was someone earmarked to overlook the system? I mean, as our office was the one that pushed for the legislation in light of the different issues, in light of what's in need and points declaration, and in light of the issues that we were seeing insofar as witness interference, jury interference, and so on and so forth. We have taken it upon ourselves to evaluate how the legislation is operating. And as you've seen, because we are the ones that pushed for the amendments, right? Where we see that there's a problem or potential problem or an area in which we can improve the legislation, then we'll make the recommendations to the Attorney General's office, and they will pick and choose whether they want to follow them or not, or to what extent.
So that's speaking to the effectiveness of it, but how do you measure success of the system?
Well, I mean, everybody might have their own criteria. Like, for example, insofar as start to finish time, insofar as length of time, efficiency, trial efficiency, I can say without a doubt, if we had a jury trial and a full jury trial and some of the matters we had judge-alone trial, we probably wouldn't be able to finish in the particular session with the amount of legal arguments that we had to make and so on and so forth. All right, that's one standpoint. You can measure effectiveness from the standpoint of efficiency. Well, we have judgments that we can read, and we can look from point A to point B to C, all the way to Z, to see how the judge arrived at his particular decision. And I mean, not because there have been convictions, but I have no difficulty with that. course, maybe the defense might say, well, if it was an acquittal, you'd probably be saying something different. But the point is, you still have that transparency whereby you can see how it is that the judge arrived at his decisions. That's another way of measuring efficiency, or if judge-alone trials are working. Insofar as it being a way to deal with witnesses who may be intimidated, well, I think the jury is still out on that one. No pun intended.
All right, so in terms of any final comments that you'd have to make, before we get there, will your department, your office, continue to educate the public on judge-alone trials? Because still there are some persons who, after even listening to this interview, may have questions still. What can your office do about that?
Well, here is what I would recommend. You see, I've told my staff, and I've gotten volunteers for this, we should take the lead role in terms of educating the public with respect to the criminal justice system here in St. Kitts and Nevis. There's a lot of misinformation out there. To that end, our office has partnered with the St. Kitts Nevis Observer to produce a weekly article on some aspect of the criminal justice system. Now, if there's a situation where persons have questions on some aspect of the justice system, and the article is generally about 800 words long, because we want something which is just enough for you to read and not take too long, take up too much of your time. They could send you the questions, and you have my contact information. You can get me those questions, and I can have counsel write an article to address the particular question, and you will find it in a next edition of the Observer. Okay. Because I believe it's important that we give back and that we realize how important our role is in terms of law reform in the Federation. Law is not static. It must move with the times.
Right. Okay. Mr. Smith, any final comments you'd like to make?
Boy, I feel like just started. You sure we don't have another hour? I know I've been up since 1 o'clock this morning. I've been excited about coming to the people and talking about this important topic, right? But what I will say, though, a parting comment, I am concerned about the level of witness interference in the Federation. It's making it difficult from the standpoint of when the government, when I say the government, I'm talking about the executive, through the police, has to put persons in witness protection. Witness protection is expensive. It takes up a lot of financial resources to put each person in witness protection. And the longer matter takes to come to trial, it's the more expense on the state. Now, in the meantime, right, some of that money could be used to health, education, or what have you. But we have that problem with witness interference. Put simple this way, for other serious matters, if you don't want judge-alone trials, don't interfere with the witnesses, because once we see that is witness interference, we're going to apply for a judge-alone trial, right? And worse yet, if I ask for an investigation and if there is evidence, trust me, you will be charged. Leave the witnesses alone, because when you interfere with witnesses, to me, you become a threat to national security and public enemy number one, and you'll be under the radar of the Director of Public Prosecutions.
Right, okay. A quick yes or no answer, because based on what you've said, have there been cases of such where persons have been charged? Yes or no? Witness tampering. Have there been cases where someone has been charged for witness tampering?
Yes.
Yes, all right, okay. We'll leave it there. That's our next show.
All right.
Thank you, viewers and listeners, for joining us for this edition of InFocus. We'd like to invite you next time to join us at the same place at the very same time for InFocus. Remember, it's your government, your business. I'm Ian Richards.
Join us every Wednesday for InFocus, a weekly talk show produced by the St. Kitts Nevis Information Service, where we provide exclusives with key persons within the government and discuss pertinent, relevant, and interesting matters that affect us all. Tune in every Wednesday, live on ZIZ Radio and streamed live on Facebook at SKNIS Media and ZIZ Online. InFocus, your government, your business.